All right, so we're on the record in docket 25-02086. That is People of the State of Michigan versus Quinton Amsiger. Amsiger, thank you. This is the time set for a prelim today. Mrs. L, your appearance for the record.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Yang.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Amsiger, who is present and to my right. My understanding is that a sub was not filed yet, but I will be substituting in as conflict counsel.
All right, thanks.
On Monday.
All right, thank you. And sir, you are Quinton Amsiger, is that correct? All right. This is the time set for a preliminary examination. Mrs. L, how are we proceeding?
Your Honor, at this
I know Mr. Yang has filed a new filing appearance and coming in as conflict counsel.
Correct, Your Honor. And at this time, we are asking for an adjournment on this matter for two reasons. One, this is a co-defendant case. This was charged with a co-defendant Alyssa Hill, case number 25-02087, which was just set yesterday for its preliminary exam on August 7th at 9 a.m. We would be asking for this to be set with that preliminary exam so that these can run simultaneously. Additionally, we believe this will give Mr. Yang the opportunity to receive and look through discovery with his client.
And is that a fair statement, Mr. Yang?
It is, Your Honor. It's kind of a joint request here due to my appointment as well as judicial economy. An offer has been extended, but we will keep reviewing that between now and then, and I'll keep Mrs. Zell updated. She did inform me of the new date of August 7th at 9, and I'm aware of that, and it works for my schedule. So I would request that the court grant that adjournment. Mr. Amsiger will be waiving his 21 days,
Okay.
Or I'd ask the court to find good cause.
I find good cause. I think this is good cause to adjourn a week. So Mr. Amsiger won't be waiving any rights today. This is a co-defendant case. We're adjourning it. Conflict counsel came in. We knew conflict counsel was going to be appointed on July 25th when Ms. Donnelly brought it to attention that this would require counsel. So we'll adjourn. I find good cause to adjourn to next week. We had Ms. Hill's probable cause conference yesterday, and we'll set for August 7th at 9 o'clock. All right, so they'll be live in person on 6th floor, just like today is. And we'll see August 7th, which will be next Thursday at 9 o'clock. Anything else for the record in 25-02086, Mrs. L?
Not for the people.
Mr. Yang?
Nothing from the defense, Your Honor.
You're all set. Thank you. Thank you, Mr. Johnson.
Thank you.
Then, Your Honor, we'll be ready on Cortez Montford, I believe. He's in custody. Oh, he's in custody. Okay. I just-
his appearance for this hearing. All right.
I just have to call the hallway one more time.
Okay. And then we'll
Tell them what's going on.
yeah, you can tell me. Are you covering for Ms. Wanji today?
I am, Your Honor.
Okay. Hey, Mr. Abbott.
I'm well, thanks. How are you?
Pretty good. Pretty good. Megan said it was a local fire, but there was a haze from Canadian fires. It's kicked up my allergy, something.
Yeah, it's a lot of smoke in the air.
Whatever's going on is going on. So, all right. So are you ready to proceed on Mr. Montford, Mrs. L?
I am, Your Honor.
All right. So we're on the record in 24-02631. That is People of the State of Michigan versus Cortez Montford. Appearances for the record of Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Abbott with the Ingham County Public Defender's Office, representing Cortez Montford. He's in custody. I'll waive his appearance.
All right. And we're waiving the appearance of Mr. Montford. He is in custody, incarcerated. And Mr. Abbott will let him know what we're doing here. Is that your understanding, Mrs. L?
That is my understanding.
All right. Mrs. L, how are we proceeding? This is set for preliminary examination today.
Your Honor, at this time, the people's necessary witnesses have failed to appear. This includes the victim in the case and the officer that was subpoenaed for today. Both were subpoenaed. We have not had successful contact with the victim in this case. We do expect a motion from the defense at this time.
Mr. Abbott.
Thank you. I move to dismiss, Your Honor.
Right, based on the defendant's motion to dismiss, people's unable to proceed based on the complaining victim failed to appear and the witness failing to appear, I'll entertain a nollie pros on 2402-631. All right, and thank you, Megan. On docket 2402-631, I'm in possession of the order of acquittal of nollie pros. It appears that there was, so I'll dismiss without prejudice based on defendant's motion to dismiss for the complaining victim failed to appear as indicated on the record. And I do not see GPS tether. There is no contact order. So you'll let Mr. Montford know that he should wait a few hours to let this purge from the system before having any contact with Ms. Currington. And if you had any questions, he can get a copy, or we can give you a copy.
I'll serve him the copy, Your Honor,
Okay.
and explain the nature of dismissal without prejudice.
All right, yeah. I mean, he should probably carry this on his person just in case. All right, anything else for the record in 2402-631, Mrs. L?
Not for the people.
Mr. Abbott?
Not from the defense.
All right, we'll give you a copy. You can give to him. Thank you for your appearance today. All right, so we can let us know when you're ready, or
I think we are ready on the Mary and Lattimore case, actually.
Lattimore.
I know that is a 9 o'clock case, but
All right, so we're on the record in 25-02116. That is People of the State of Michigan versus Nary and Lattimore. Appearances for the record, Mrs. L.
thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Lattimore. He stands present to my right.
And sir, you are Narian Lattimore, is that correct?
Counsel Narian, yes, sir.
Narian, thank you. This is the time set for a preliminary examination. Today, Mrs. L, how are we proceeding?
Your Honor, at this time, a plea offer has been extended to defense to be preserved up in circuit court. That offer is for Mr. Lattimore to plead guilty to an attempt strangulation under NCL 750.84 with an A after it, and a count of DV. This would be open until the first pretrial in circuit court. Upon successful plea and sentencing, we would be dismissing the count 1, which is the full strangulation, for that attempt strangulation instead.
All right, and is that your understanding of the offer, Mr. Austin?
One moment, if I may.
Additionally, Your Honor, we would also be agreeing upon this plea to not seek additional charges of witness interference in this case.
And with that, Your Honor, that is my full understanding of what the offer is. That's what I conveyed to Mr. Lattimore.
All right, with the understanding of the offer being placed on the record, Mr. Austin may inquire of your client of his waiver of the preliminary examination.
Yes, you may.
All right, Mr. Lattimore, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Jared Austin. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding, it is your wish today to waive your right to preliminary examination, have this case continue in circuit court, where the offer that's been placed on the record will be open to the first circuit court pretrial. Is it your understanding that it is your wish to waive your right to preliminary examination based on the offer that's been presented?
Yes, sir.
Ms. Izell, the people also waive their right to a preliminary examination.
We do, Your Honor.
Yeah, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation for signatures. All right, I'm in possession of the bind over documentation on docket 2502-116, signed by all the parties. I will indicate the examination was waived on today's date. The defendant was bound over on all the charges, and the terms of the offer have been placed on the record. Anything else before I sign the bind over documentation on 2502-116, Mrs. L?
No, Your Honor, not for the people.
Mr. Austin?
If I may address an aspect of bond, Your Honor.
Absolutely.
Thank you, Your Honor. The complaining witness in this case is Mr. Lattimore's wife. The location of the alleged offense is the marital property where they're both leaseholders. Mr. Lattimore, as part of his bond conditions, is restricted from going back there for that reason. It's become a bit of a financial burden for him because not only is he, I think, responsible for the rent to that property, but he's also having to pay for his own lodging. Now, to what extent this has been confirmed or not, I'm not sure, but at least there was some discussions, I believe, that people had with the complaining witness in this case, indicating that she had either moved out of that property or was going to move out very shortly after the alleged offense took place and was going to be moving out of state. So I would ask the court if it would consider modifying Mr. Lattimore's bond that he could return to that property, given that. Now, I've explained to Mr. Lattimore, as I'm sure the court will as well, if the court were to grant him that modification, obviously the no contact order is still in place. I think his wife as a leaseholder would have a legal right to be there if she wished. And if she were to return to that property, the onus is on him to leave immediately or else he would be in violation of the no contact order. But given those representations, Your Honor, I would ask the court to consider modifying his bond to allow him to return to that property, provided that his wife is not there.
All right, thank you. Have you had any contact with the victim in the case, Miss Amber Lattimore, concerning the no contact order?
We have, Your Honor. She has asked us to move for it to be removed. We are not agreeing to that at this time. However, she did confirm that she did move to Indiana, or at least she gave us an address to where she will be staying in Indiana. We aren't fully convinced that that she is out of the home, but we would understand if the court would take her at her word. She is here and present in another area of the courtroom or courthouse today, if you would like to speak to her.
I guess if we're gonna lift the no contact order, there would be a continuing no contact order. I would like to hear from her. And then I would lift it with the understanding if no contact order stays in place, he's just allowed to be back at the home because she's moved out of state.
And just to be clear, Your Honor, that's what I was asking the court to do. I wasn't asking the court to just fully lift the no contact order, just to permit Mr. Lattimore to go back to that property, provided that she isn't there. And if she comes there, then the onus is on him to leave immediately.
Correct, or contact law enforcement for the same reason. I'd like that placed on the record, just in case.
Yes, if I could just have a moment to.
Absolutely. Mr. Carter, how are you?
Good. Sorry I stood you guys up on Tuesday.
You were busy.
I didn't realize I should have, but it slipped my mind to do a stiff north.
That's all right.
I felt bad. I'm like, when I'm a real jerk.
It happens.
It happened. I knew what was going on. I kept checking the clerks to make sure that I didn't just miss it because it's just not like you. That's why
I guess if there's a pattern of behavior, we get worried. It's Mr. Carter. It's not like there's a pattern of behavior.
Well, thank you.
She wasn't back.
Drew, do you want to sign a sum of counsel for Ms. Dunn?
Sure.
And for Mr. Yang?
Yes, he sent it to me instead of clerks, but we'll just
Okay.
get this handled with the least amount of, oh, but she does, you don't have it yet, it should be printing. But you know, if I send it to the right printer, it'll print it.
Like, it has a mind of its own.
It does, and this, I have two printers, and if I don't do the right one, the courtroom one, it just gets all sassy hands.
Too late now.
All right, so we're back on the record in docket 2502-116. That is the preliminary examination concerning Marion Lattimore. And ma'am, you are Amber Lattimore, is that correct?
Yes.
All right, thank you. This is the time set for preliminary examination. The examination's been waived today. And then there was an indication made today by defense counsel that you are no longer living in the state. Is that correct?
That is correct.
Where are you living now, ma'am?
I'm living with my mother in Lebanon, Indiana.
Okay, so you're in Indiana now. And so the request has been made that the defendant be allowed to go back to the residence. And would that put him in violation of the no contact order?
No, I am not there.
All right, so I will find that placed on the record that the complaining victim has indicated, the alleged complaining victims indicated that they're living in Indiana. And do you have any objection to the defendant going back to the house?
No, sir.
There's no objection to defendant going back to the house. I'm going to continue the no contact order. So Mr. Lattimore is still under no contact order with you, but he won't be in violation of the order if he goes back to the house. All right, any questions, Mrs. L?
No, Your Honor.
All right, Ms. Lattimore, thank you for your appearance today. We can finish the preliminary examination bind over. I just wanted it on the record. So if I lift the ability for Mr. Lattimore to go back to the house, the no contact order is still in place, all right? So if the onus falls on Mr. Lattimore, if there's any contact, he's to run away, you know that. And then if you have any contact with Mr. Lattimore, that you should contact law enforcement, okay?
Yes, sir.
All right, thank you. You may leave now, ma'am. Oh, an updated address. So is that address going to be your home address? Because we have the hotel as your address now.
Oh, yes, sir.
Okay. So that address will be
3401.
01 Rayburn Drive,
Yes, Your Honor.
Lansing, Michigan.
Yes, Your Honor.
So it's the same one as it was before on the complaint. All right. So I will modify the bond to allow D to go back to residence. But not lift the no contact order.
Thank you, Your Honor.
All right. Anything else from Mr. Austin on 2502-116 before I sign the bind over documentation?
I have nothing additional on behalf of Mr. Lattimore,
All
Your Honor.
right.
Thank you.
Mr. Lattimore, your time in district court is done. You're off to circuit court, but you'll get your next date to appear in circuit court from your attorney, Mr. Austin. All right, sir?
Thank you.
All right. This is August. All right.
Already.
Already is right. All right, you're off to circuit court. Your time in district court is done. Thank you for your appearance today, Mr. Lattimore.
Thank you.
Okay, for a second, I want to make sure the coast is clear. Yeah, stay in court.
Yeah.
Your Honor, I'm just gonna step out briefly. I'll be right.
All right. And if you need some additional, if you need time to talk to witnesses, let me know. Mr. Yang.
Yeah, I just wanna get that to you guys, I can get it, since it's kind of a fast turn. Yes, because I was trying to do this for July.
Me too. August 1st.
We don't need, well, Susie's gonna send it back, and we're gonna say. Because it wasn't specific for that address, it's just whatever.
I don't know if there's a no contact order with the residents. It was on.
The generic, not to be within 2,000 feet of where she lives, works, or goes to school, so we don't need to modify it, that's what I checked. That's what I was checking. And then. you give me back this- this one out there, and you have that. Thank you. Judge, can you mute us?
Yes.